Right. Welcome to the July 2nd, 2025 meeting of the Thurston County Planning Commission. The Thurston County Planning Commission is a resident advisory committee to the Board of County Commissioners on land use planning matters such as the comprehensive plan and zoning ordinance amendments. Planning Commission actions are in the form of recommendations to the county commissioners, who are the final decision makers. All Planning Commission meetings are open to the public. Community members are welcome to observe all Planning Commission briefings and work sessions. We will start with introductions, which I almost always forget because it's not on my script, but to my left.
My name is Eric Casino. I live in the Lacey UGA and I serve at large.
I'm Colin Bartlett. I serve at large for District 5. I live in Tumwater.
Scott Nelson, District 4.
Sandy Kaiser, District 3.
Daniel Baumbarger. I live and serve in District 1.
Yvonne Miller for District 1.
Kevin Pessinger, District 5.
Barry Halverson, Yelm, Washington, District 2.
And Joel Hanson serving District 3.
Bill Fishburne, living and serving in District 4.
Oh, thank you, Commissioner Fishburne, and thank you for not the screen yet. So thanks for just jumping in, and feel free to do that if I'm ignoring you throughout the meeting because I'm.
You bet.
We have an agenda in front of us, and I would entertain a motion to approve.
So moved.
Second.
Okay. It's been moved and seconded. Is there any discussion on the agenda or any things that we might want to adjust?
Be a long night.
It's gonna be a long night. Okay, well then we'll, all those in favor of the agenda as presented?
Aye.
Aye.
Okay, then next on our agenda is the approval of meeting minutes from June 4th and June 18th. To speed this up, can we take a motion to approve both if we don't have comments?
I'll move to approve the meeting minutes for June 4th and June 18th, 2025, and use the audio recording as the recording.
Okay, is there a second?
Second.
Is there any discussion?
The only minor concern is that people abstaining from not being present will be different.
Oh, I think we'll be okay. If there are no substantive changes to the meeting minutes, I feel comfortable voting even though I wasn't here. I've listened to the meeting. All those in favor of the meeting minutes as presented?
Aye.
Aye.
Fantastic. Now we are to the portion of our meeting where we take public comment. The Thurston County Planning Commission welcomes comments from the public at all meetings. General speaking guidelines, please introduce yourself and include the address where you reside in the county. Please address the Planning Commission, not the audience or staff. The Planning Commission may not respond to public comments. Speakers are limited to a total of 3 minutes. The timer will show on one of the video screens. Help keep track of time. Meeting attendees cannot donate their speaking time to another person. No comments that are lewd and offensive, inflammatory, hateful, defamatory, or discriminatory in nature will be allowed. No comments that are commercial in nature. All materials provided to the county may be subject to release pursuant to the Public Records Act, and remarks on projects that have already had a Planning Commission public hearing will be forwarded to the Board of County Commissioners for their consideration.
Point of information.
Yes, sir.
That statement you just read had an early on in it, a statement about planning commissioners will not comment on public comment. We've gotten into the habit of doing that. I'm fine either way, but let's not say we won't if we won't, if we will.
Thank you.
Yeah,
Did you say not necessarily?
it doesn't, but
Yeah, it may not, if it's like might not, may not. as
may
in
not. Yeah, they may
it's
not.
Different, yeah.
I could interpret it that way. It
Yeah.
says planning commissioners may not respond to
May
public
is
comment.
conditional.
Yeah,
It's not a guarantee of a response.
Fair enough.
right. That works for me. Okay, do I have a list or should I start online?
You have a list. It's getting longer.
Oh.
Start online if you want it.
Okay. Do we have anybody online that wishes to give comment tonight? please indicate so by raising your hand virtually.
Is it worth distinguishing that if you have comment for the hearing, maybe save that for the hearing?
Oh.
And if you have general
Yeah.
public comment, then do it now,
So
if you think it's worth distinguishing.
I think it is because we might have some confusion otherwise.
There's technically 2 opportunities to speak as well.
Yeah.
Right.
Truncate people's available time.
Right. So the public hearing. No, okay, okay, the hearing. Okay. So not seeing any hands raised online, we will, oh, there's one, David Torrey. We'll start in the room with the just general public comments. And then later in the meeting, we'll have an opportunity for comments for the public hearing on the permit review process. Does that make sense? So the first person signed up to give public comment tonight is Seth. Ooh, is it Prince? Priggy, okay.
Yes.
Sorry for that.
Do I need to go over there?
Yep, could you go to the podium and then state your name and address, and then you've got 3 minutes.
All right, my name is Seth Berge. I live at 138th and Rainier, Thurston County. I also work Mountain to Coast Land Surveying, locally out of Tumwater. I'm here to ask for support about 40-acre subdivisions that code ordinance had changed in 2022 under ordinance 16227. They removed the subdivision requirements for the finding exceptions to no longer allow division of land over 40 acres. I understand this may, now that I'm learning more, may not be directly related to the plan, your guys' board, but what I'm asking for is your support in bringing that back, or another number, having a number. If you own, say, 400 acres and you want to sell 40 acres off of timberland, farmland, seems reasonable that you should be able to do that without having to go through the whole planning process. Because you cannot do a large lot over 40 acres currently, as it's written in section 18 of the code. So you have to go through a full plating process, which also includes wetland delineations, critical areas, steep slopes, which is a significant expense along with permitting fees. So I am also writing a letter to the Board of County Commissioners. And what I'm just asking for is your support so that we can get that in reinstated or added to section 1804045 as a legal lot criteria. I've ran into multiple cases as a surveyor where people want to divide, say, 150 acres into 3 lots to give to their family. And they basically have to go through a testamentary division to do that without going through the full plating process. And it seems unreasonable. Most of the other counties have exceptions. Pierce County has a 100-acre exception. Lewis County is at 5 acres. I know Mason has one, and other surrounding area counties. So, yeah, that was my request for support in that area there.
Thank you. Appreciate that. Next on the list to give public comment is Mr. John Pettit.
Good evening. My name is John Pettit, 9725 Rich Road, Southeast Olympia, Washington. I have a place called Deschutes River Ranch, and you should all be down there. It's much cooler and much more enjoyable. But I appreciate the fact that you're all here doing voluntary time. I know you're not here for the paycheck. Okay, because you aren't getting any. And I don't want to see you guys using your time or necessarily becoming a rubber stamp for or staff process just to have you go through and approve something, given a limited amount of information and time to truly study it. So, interesting, the gentleman who just made a comment about division of land. I've been a real estate broker since I was 18 years old. We used to be able to just divide 5 acres off by making getting a legal description and filing it. It was done. Now I help people that are in crisis modes because of the difficulties of going through the gauntlet of Thurston County planning and the system. People go for years trying to get an example, just give away 5 acres to a loyal employee. Cost tens of thousands of dollars to process it because they want to do something special for people that have earned the right. But it costs them so much money to give away property that would be $250,000 or more. The system needs to get refixed, not just set up to collect more money from the county, but to allow people to enjoy the benefit of their property. Property rights are a constitutional right, and the more restrictions that are on them is difficult. I would encourage that you listen to this gentleman, try to abide by, but exceed it, put it back closer to being valuable. I have other people right now that are in conflict over other issues. In fact, one example is I have somebody that's trying to deal with gopher issues right now. The gopher fees are actually more than the entire value of the property. So if you want to develop 12 acres, you need to essentially pay for more than 12 acres worth of property in order to get a chance to help develop property, like 70 lots to have affordable housing. We've been worked over, you have been worked over, thinking that sometimes you're supporting what looks like a good environmental cause. But the bottom line is it's not necessarily helping the people. We appreciate your help. Thank you for being here, doing it. Make sure you take the time and study it out to know what's best overall for the people so you can make good recommendations to the commissioners. Thank you.
Thank you, Mr. Pettit. And that's the end of my list in the room. So I see Mr. Toyer would like to give public comment.
There's a few others in the.
Oh, but you're here for the permit review public hearing, right? Yeah, that'll be just in a little bit. That'll come up at 7 o'clock.
I've got a hand raised over there.
Oh, you want to? Okay, Kristen, sure.
Good evening, commissioners. My name is Christy White and I live in the Delphi Valley. It is very hard work all of you do, and there are many in the community like you who volunteer their time and energy for the benefit of Thurston County residents and businesses. My comments this evening are to honor one of the great citizen volunteers and advocates. Sue Danver passed away this weekend. Many of you know her, and some of you may not have had the opportunity to meet a real champion of environmental protection in the county. Sue dedicated countless hours and work to support conservation and policy to benefit county. Many times Sue would tell me she was going to retire from her activities. And then another item would come up on the docket or a hearing or something in the wind that didn't sit right, and she would take it full on. Sue knew how to connect and rally the troops. Her ability to reach out and make us aware of meetings to attend, comments to write, petitions to sign, and hearings to testify to was a remarkable skill. She taught me a lot as I learned about the workings of county government. I'm still trying to understand all of it. She and I might be working on different items, but we always tried to support the other, even if we were not expecting it. Coming to a planning commission or commissioners meeting or a hearing, I would often be surprised to see someone in the room I knew. It was Sue, with her signature hair bandana that she always wore. It is difficult to be a citizen advocate, and Sue never gave up. She always tried to find opportunities to work with the Planning Commission. I hope you will appreciate and honor her by your continued work that will keep Thurston County an emerald gem. I think Sue would like that. It would be a fine legacy for her. Thank you.
Thank you. Appreciate that. Okay, now we have one hand raised online. Mr. Toyer, if you have public comment that you'd like to give, please unmute yourself and go ahead.
Yeah, can you hear me?
We can, thank you.
Awesome, thank you. Appreciate your time tonight. Commissioners, my name is David Toyer with Toyer Strategic Advisors, located up here in Everett, Washington. We're the land use consultant for Black Lake Quarry on the Littlerock proposal that you're having a third work session on later this evening. I know that there have been a number of questions. We submitted some additional information back on the 18th of last month. And there was a county visit out to the site to kind of take a look at the site's current conditions. Just would strongly encourage the commissioners tonight to go ahead and schedule a public hearing for this proposal. We'd like to be able to move on and provide additional information as needed, answer additional questions as they come up. You know, bottom line, this site is currently being mined. It's a very active site. It's been heavily disturbed, and the proposed rezone and land use redesignation would really give us some opportunities to look at potential related business enterprises on portions of the site that have been mined. And, you know, I think it's important the commission, you know, recognize that there's been a substantial amount of studies, technical research and reporting done on the mining, both for permitting as well as kind of ongoing compliance and performance. And then if there was to be a land use proposal in the future, you know, after such time as a rezone would be approved, that land use proposal would still have to go through its own environmental review, its own process of having to submit studies and technical data and other information to justify why it should be allowed on the site. So the rezone itself is not the final thing that takes place. And we just ask you to keep that in mind as you weigh the proposal and make a future decision. So hopefully we get an opportunity to have a public hearing soon, but really appreciate your time, especially all the time you've been spending this year in commission meetings dealing with a number of weighty issues from the comp plan to other updates that are necessary to the code because of legislative changes. So thanks, appreciate it.
Thank you, Mr. Toyer. I don't see any more hands raised online. Nobody else in the room wants to give public comment? Okay, we're here for the other hearing. Okay, so moving on in our agenda. Item number 4, work session number 1 on the 26 to 31 capital improvement program update. We have Anna making a presentation.
Yes.
Okay.
There we go. Good evening, commissioners. I know we only have 9 minutes until the public hearing, so it's going to be a very, very introductory piece on the CIP. Andrew Bond, Community Development Manager, it actually took a day off. So he's not here, but he's been part of this process and shepherding it through much more hands-on than I have. So this is for the 2026-2031 capital program. You've probably all seen in your packet, it looks very different. We want to take some time to talk about why it looks that way, ways that we can actually make this a valuable community resource, because it wasn't in the past and it might not be in this current iteration. There are likely some more tweaks and such that need to take place, and so we'd like to hear from you all on that. We'll walk through what the historic CIP looked like, alongside walking through this current draft that you all have. And we'll hopefully schedule a public hearing for this for next month. Anything to add?
How many of you remember the CIP process from last year? Only about 4, so there's some historical memory in the room.
Will somebody care to summarize it? I think it can be done in less than 1 sentence.
We refused.
Out of a lack of time available to evaluate the data.
And any real authority to make a decision there, or to have an impactful decision there.
And I will say that part we can't change for this year, like the timeline, the timeline crunch that y'all felt last year. It still exists this year. What we're proposing is to adjust the timeline so that future reviews of the CIP do not have that same crunch where it has to be done by the end of the year and has to sort of come to the board at the same time that the budget is coming to the board for that.
So if I were to entertain a motion that basically said we aren't going to participate in this process again this year, would that reinforce the idea that it needs to be fixed for next year?
What would be great is to take a look at what we've come up with working with our partners in Public Works and Central Services to see if what is moving forward to the board does a better job of reflecting the feedback that we've seen from the process standpoint, as well as the actual document standpoint.
Okay. Take it away.
And then you can still say that you.
I
after
have a
that.
feeling that's where we're gonna get to.
We had informed one of those.
Yeah.
Informed or
But maybe we can
And
do
after the
that
public hearing.
in a way to send a message like, yeah, you're on the right track, keep going.
Yeah. But make sure it's after the public hearing.
Okay.
I will point out, we've got Matt and Xavier, who actually came in person from Public Works. We've also got Rick Thomas and Jason Ash online. So should we reach a point after the public hearing where you might have some more departmental specific questions, I do have people that can answer those for you. You know, last year I could not. And so what is the CIP? Some of you already know, but for the record, it's a 6-year plan of community investments for Thurston County. And so in looking at the document, that includes things like county-owned water and sewer, transportation, stormwater, government buildings, solid waste. I'm likely missing one. It says it right here on the screen. So it's for projects anticipated to cost about $100,000 or more with a 10-year life cycle, or anything that's funded with real estate excise tax, REIT funds, or impact fees. And so one thing to note is Chapter 8 of the CIP is things like schools and fire facilities. While we do not have jurisdiction over them, we are required to reach out to those entities to make sure that our CIP reflects capital projects that they may be having. So I've already done that, and many of them have said, we'll get back to you in October. So for those that will respond, those numbers might look different as this reaches the board stage, but that is a pivotal piece of this, as well as interacting with them alongside our county partners.
In that vein, how many revenue sources are at risk from being attached to federal funding?
Not a lot. Of county departments, public health probably have the most programs that are affected directly by what's happening at the federal level. Matt could speak to whether we have any transportation projects that are affected in the near term.
I'm the Thurston County engineer. So actually, the timing's great because I just put out an e-brief to the county commissioners about this very issue. And we actually have $9 million of transportation funding that could be impacted by some of the proposed interpretations of the federal legislation.
Big, beautiful bill.
So it's impactful. That being said, we're not getting really any solid guidance yet, which is frustrating. We've reached out to WashDOT. WashDOT has received, we've been told that they've received very little guidance from the federal government. So it's a waiting game at this point, but there's definitely a solid $9 million within our transportation budget that could be impacted.
First of all, thank you for being here and thank you to all of you for making the time. Would that mean that the plan as it exists today has that $9 million of funding in it? And it would need to be amended if the funding.
You're tracking.
Okay.
So
Yeah.
that is when we're listing out our revenues over the next 6 years, those dollar amounts are included.
Okay.
Some of that funding's committed, some of it has not been committed yet, and we'll have to go through the obligation process in the upcoming years to obligate those funds.
And correct me if I'm wrong, but the nearer term projects are more likely to have committed funds versus the outer year projects.
It's once you get beyond 2025 and 2026, I've been told we're probably okay because we've committed most of that funds, but once you get out to 2027, we haven't committed those future project phases. You have to get the previous project phases done first.
And the CIP would not have to be amended if we are not able to realize projects. It's a bigger issue if the project isn't in there and the funds become available.
Sure, okay, got
We
it.
would more likely update it
Updated, yeah.
next time.
Made it to just extend timelines and things like that. Sure. Okay,
Great question.
thank you. Any other questions? Okay. Please.
Yeah, sure, okay, 3 minutes. That could be 3 slides.
And this clock's about a minute fast.
Mine
Our
worked.
timekeeper.
Need a new title.
So this slide, I should have amended the title to say past issues and identified solutions. So on the left, we've got this graphic about many things the CIP is too long. It was over 100 pages. It took too many staff and way too many hours to develop. A lot of meetings, really repetitive, going to the board for an all-day briefing that took tons of departmental staff, not just from CPED. And like you all have voiced, it was really a rubber stamp. You didn't have enough time to look at it and you were just told you have to push it along to the board without much of a say. And so we've tried to reduce the size and mirror what some of the other jurisdiction CIPs look like. Ours was really long for kind of no good reason. So hopefully shortening it and then having a link to an external page would increase transparency, having this online platform. If it's referenced in the CIP and we have this webpage, the webpage can be updated like that, whereas the CIP amendment process is 60 days. And so hopefully that increases transparency with the projects that are taking place, migrating to a biennial adoption instead of doing this annually every other year. And like I said at the beginning, trying to make this more of a community resource. We might not be there yet, but that's really what we're trying to focus on is what are the priorities? What are things that we can do? What are ways to, what are the solutions to things and priorities that we've identified?
I think what we realized as we started doing research into other counties and speaking with some of the planning commissioners is you can set up your document to be this very wonky, technical, long document, and then it becomes not very useful or approachable. And if the role of the capital facilities plan and the capital improvement program is really about just the county demonstrating that it is thinking about its growth over the next over the 20-year horizon, that it's identifying what's needed in terms of facilities and infrastructure and buildings to accommodate that growth, that might be better to create an approachable document that is more narrative in format to tell the story of like, yes, we are aware that we have these issues and how are we addressing them? What are the options that are available to us? The online platform is definitely a way more useful and easy way to get that information out to the community. And we've been talking to Public Works and Central Services about one place where those things live rather than having to navigate multiple websites of these various departments. So still a work in progress, but really just trying to look at it through a different lens of like, how do you meet the requirements in state law and actually create something that might be useful and less wonky than hundreds of pages of numbers or tables. We're open to receive what y'all think about that and places where we can add content to really meet that goal. And be our user testers for our new online platform.
Is it a good time to take pause to move to our public hearing? Okay. Let's do that.
Are we gonna come back to this
Yes,
before we move on to the next item on the agenda?
it's up to you all. If you would like to have a hearing on this item and then have work session on the public hearing item, we can. If you would like to have a hearing, talk about CIP and then return to the work session on permit review, I'm here either way, so I can go
Yeah,
whatever direction
my
you all would like.
comment is, I just don't know that we need to tie up staff for the next half hour to an hour. Cause we're not gonna be able to talk about it very long when you look at the agenda we've got tonight. That's why.
Okay. Seeing as how
Is
it's,
is that an actionable suggestion? Just want to double check there.
Well, she's gonna be here for multiple
I'm not
subjects.
talking
anyway.
about Anna, I'm talking about.
Oh,
Oh, yeah.
Thank you for your
Okay.
consideration.
I gave them a heads up that
Okay,
we
I
have a
just,
very packed agenda.
Yeah, I mean, if you are not gonna have specific questions about particular projects, then I would say let our friends in central services and public works go, and we can always follow up with them and get answers.
yeah, I mean. I'm not gonna have questions about specific projects.
Then I say.
Is that true for anyone else? Does anyone else have specific projects they want to ask questions for at this point?
probably not today.
My suggestion would be that I think this is really about like the overall structure and process, so it's probably not the best time.
Okay.
Yeah, you're right.
Yeah.
Send them home.
I would.
Yeah.
I would send
You
them
guys
home.
don't have to stay. You're welcome to stay, but it's a beautiful evening out there.
Thank you, Jason. That means you all can also log off. But thank you so much for hopping on.
Thank you for being here. Okay, seeing as it's after 7 p.m., we will now go into the public hearing for the permit review process annual code updates. The purpose of today's hearing, we're here to hold a public hearing on the development code docket item A31, permit review process annual code update. There is a sign-in sheet in the entrance to the room. If you wish to testify, please make sure that you signed in. If you are on Zoom and wish to testify, please choose the raise your hand option. If you are dialing in, press 9 to raise your hand, and the chair will call your name and unmute, and you will be unmuted when it's your turn to speak. Make sure you also choose *6 to unmute yourself if you're on your mobile phone. Each person will have 3 minutes to testify. Names will be called in the order that they appear on the sheet. And when you hear your name, please come forward to testify. You may not give time to another person, and please provide your name and address for the record. First, we will have a staff presentation. And to provide background information, a review of the comments submitted, and any additional information requested by the Planning Commission, and then we will move to testimony.
Let me share my screen really quickly again. Computer froze. I know what I need to say, if you all are okay with me just moving forward without a visual, just for the interest of time. This is a public hearing on the permit review process annual update development code docket item. The package under consideration tonight includes appeals process, amendments to SEPA categorical exemption thresholds, updating our administrative procedures to reflect the Senate Bill 5290 permit review timelines, as well as some minor clerical edits. We have, my computer, okay, maybe my computer is working and I never hit share screen. I apologize, everyone. There we go. as I mentioned, we've got these 4 buckets of sorts. It is a lengthy code package and it does include, a lot of things. The code clarifications and corrections includes revisions to titles 17, 18, 20, and 25. Permit review timelines, as I mentioned, it amends our administrative procedures, which exist in titles 18, 20, 21, 22, 23, and 24. Our code is incredibly redundant. And so that is part of why our code package is so long, because we have administrative procedures within multiple titles. Appeals, as mentioned previously in work sessions, this is an item directed by the Board of County Commissioners, and it removes them from the appeals process. And so appeals of hearing examiner decisions would then go to Superior Court. This would allow the board to be more engaged in with applicants who have land use proposals under review. And then lastly, SEPA categorical exemptions. This amends Title 17 exemptions as allowed by the Senate bill passed in 2023. The process to date, you all had your first work session on July 10th, 2024, and then we returned on May 21st, 2025 for our second work session. We had a third work session, June 4th, and you all scheduled a public hearing for today, July 2nd, 2025. In advance of this public hearing, legal notice was issued in the Nisqually Valley News on June 12th. A press release was issued on June 20th, and a web mail was sent to all of our subscribers on June 20th as well. Staff received 72 comments. There are a couple duplicates in there. So it's 72 distinct comments in advance of this hearing. The Planning Commission received initial comments in an email yesterday, and any comments that were submitted after 1:30 p.m. yesterday. They had been emailed to you all, as well as printed and provided with your materials. And then lastly, just thank you for any members of the public who have questions following this. My email is on the slide. I look forward to hearing the testimony that we have tonight and discussing the Planning Commission's recommendation.
Thank you very much. So first signed up to testify here in the room is Betsy North.
Hi, my name is Betsy Norton. I live in Olympia. And I'm here representing South Sound Bird Alliance, formerly the Black Lake Quarry Society. We submitted comments with 3 main objections, and I'm working on number 3 just because I happen to be here. So dear Planning Commissioners, the South Sound Bird Alliance Conservation Committee has 3 concerns, and this is the 3rd one. We do not support the proposal to remove administrative appeals when the county's planning director decides permit requests to allow unclassified uses, whether that be in a backyard, a planned industrial park, or a light industrial zone. Because this is a time of unprecedented growth and innovation, there are likely to be some significant number of unclassified uses which require permitting decisions. For instance, I expect to see new uses associated with data centers, hydrogen power, wood pellet production, battery or wood product manufacturing. The planning director is probably not an expert in all aspects of wildlife locations, habitat, and potential for environmental harm, nor are they likely to be intimately familiar with the location as a neighbor would be. Public input may better inform the director when it comes to assessing whether the proposed use is appropriate for a site. The proposal to remove the appealability here means the public has to take the decision to Superior Court to have an impact, which is way too expensive for most residents. Please do not remove the ability to appeal the community planning director's decision on classified uses, so neighbors have a say in unclassified use permit approval. This applies generally to all 3 instances of this proposal, including 20.07.060, 20.27.020F, and 20.28.020I. Please see our more detailed comments submitted in writing. Thank you.
Next. Not read that name. Is it
John Pettit.
Is it John Pettit? Okay.
I think you have 2 people listed, so.
We've got 4 now, and I think some hands online, so, but thank you, Mr. Pettit.
Okay, good evening. My name is John Pettit, 9725 Ridge Road, Southeast Olympia. And my comments is kind of First, I'm gonna start out with this. I don't think you've actually had true public exposure to this. Point blank. How many people have you actually had come in and actually know about all of these things? What type of a presentation did we actually have here tonight for people that would actually have it? I can assure you, and not all the time do I necessarily agree with the previous person, but I will put it this way. Power that suddenly is developed and excludes a process that would in fact be the representative government that we have in this county is not a good thing just to empower people that they can go ahead and have authority. That's one of the most amazing things that's ever happened is people suddenly decide a little pocket benefit to something and they get an approval, nobody ever has to know. Or maybe somebody just has a personal agenda that they're seeking, and so they use their position and their power to push their agenda rather than the good of the general public. So our representatives are there for a reason. We should never eliminate that representative government in favor of some type of local dictator of zoning or land use. I think that the idea that you have over 300,000 people that live in Thurston County, and how many people have actually come and had a chance to talk to you about this? How many people go through a variety of applications? I'm encouraging, if you're gonna do something, make it based upon hardcore. Adjusting a few things to the actual law is one thing. Adjusting a few things to a law with using interpretive words the way you want to twist it is a totally different thing. I think it would be better to say, I'm not making a recommendation on this, and to be the rubber stamp and say, we're gonna do it because there's a limited time frame. I've had applications that were applied for back in 23 and they're still not even though what you guys approved everything, staff still never got it through. So it still pens out here for another balance of time. Your time is important. And if you're gonna be valid, you need to be listened to. And what I wanna see is I wanna see you guys actually do what's intended here, which is get the public and represent public interest. Thank you very much.
Thank you, Mr. Pettit. Next sign up to testify is it Lori Chase?
Nice to see you all in person. Usually I'm one of those people up there. So I'm a little nervous about being here. So I also am a member of South Sound Bird Alliance on the Conservation Committee. And our formal comments were already submitted, as Betsy already told you. So the major concerns that I have are the following. The lack of environmental review and accountability, the permit process and the annual draft update. There's no documentation that I can see or that the committee has found that reviews the impacts that are proposed or any mitigation that's proposed. And you guys are proposing to give everybody the maximum exemption that they can get. So what's going on here? We want to see all the SEPA information that we can. Ignoring environmental impacts will have negative consequences forever. They're going to impact water availability. It's going to increase impervious surfaces. So what's going to happen to our aquifers? There's going to be the recharge availability for the water. And it's going to diminish the environment that we live in and that we don't want to take for granted. I want to see Thurston County grow and prosper, just like everybody else, but I don't want to see it grow at the expense of habitat, and fresh water and fresh air. So I would ask that you consider not raising the ZEPA thresholds to maximum allowed that I've seen being proposed, and that you use your discretionary power to change the thresholds to something more reasonable.
Thank you. Okay, next signed up to testify is Charlotte Person.
Good evening, I'm Charlotte Persons and I live in Olympia. Today I also represent South Sound Bird Alliance, formerly Black Hills Audubon Society. Lori has just spoken about our serious concern about the huge increase in the size of projects proposed for exemption from SEPA review in the draft review update. I'm speaking about another concern of the South Sound Bird Alliance. The draft review update in most cases removes the option for appellants to appeal a hearing examiner decision to the Board of County Commissioners. It also removes the requirement for open hearings for the few remaining decisions the Board of County Commissioners will make. These new procedures are undemocratic. We object to them for two important reasons. First, by removing most appeals to the Board of County Commissioners and closing public access to the few remaining appeals to that body, the public will not hear their elected county commissioners consider the pros and cons of exempting building projects from SEPA review. This lack of transparency is especially concerning if the construction projects under review will be large, potentially larger than the projects currently proposed for exemption. Second, an appeal to the Superior Court is very costly when taking into account both the court fees and lawyer expenses. In effect, this expense will prevent many members of the public from filing. In turn, no appeals or few appeals will place too much decision-making power in the hands of the hearing examiner and county staff. We urge the planning commissioners to recommend to the Board of County Commissioners to reject the proposed changes in the draft review. The citizens of Thurston County deserve a transparent and democratic appeals process.
Thank you, Charlotte. And I understand Rhonda, you'd like to testify.
My name is Rhonda Larson Kramer. I live at 1814 East Side Street, Southeast Olympia. At the outset, I wanted to ask the county to please fix the minor amendments process so that the proposed major policy changes don't end up on the minor amendments list. That webpage states, quote, the minor amendment page contains minor projects that are procedural, clerical, or improvements to the existing process, unquote. That improvements to the process clause can mean anything. It's too vague, and it's in the eyes of the beholder whether something is an actual improvement or harms the process. This vagueness undermines transparency because it allows staff to put major policy changes into that bucket when they avoid proper public scrutiny. For example, I have 3 minutes merely to address the 2 bad things on the list today, and that is not enough time to give the needed information to decision makers. As for those 2 bad things, they are both major policy changes. They really have no business being on a minor amendment list. The first is the taking away of the public's right to seek redress from the Board of County Commissioners when a hearing officer makes a bad decision on a permit application. Under current code, if the hearing examiner makes a bad decision, the public can appeal it to the Board of County Commissioners. And the commissioners do not have to presume that the hearing examiner's decision is correct. That's called the presumption of correctness. It doesn't apply in an appeal to the Board of County Commissioners. In contrast, the appeal to a Superior Court, the judge has to apply the presumption of correctness. They have to presume the hearing examiner's decision was correct. That makes it almost impossible for the public to succeed in an appeal to the Superior Court. Another difference is that the county commissioners can rule based on policy reasons. In contrast, the Superior Court cannot. That means the changes that you're looked at are gonna reduce the likelihood of the end result being good policy. Also, in an appeal to the county commissioners, the public doesn't need an attorney. And by contrast, you really do need an attorney in Superior Court. Most members of the public are not in a position to hire an attorney, and so they're really at a disadvantage compared to the project applicants, which are very familiar with the project, often have a ton of money. So this results in bad outcomes for the public on so many levels, and our quality of life is gonna degrade as a result. As for proposed policy change number 2, it similarly undermines democracy. It says no environmental review is needed to build 20 units of housing outside the urban growth area. That proposed change is not legal. The 2023 law allowing cities and counties to create an exemption from SEPA for any proposed developments of up to 20 housing units inside the urban growth area applies only to proposals of housing units inside the urban growth area. Nowhere does the law allow the county to exempt developments outside the urban growth area for 20 units. Also, even if it were legal, the public relies on SEPA as the only real way to stop illegal development and development that is bad policy. So please, at the very least, remove these major policy proposals from the minor amendments list and make them the docket items and give them the transparency that they are due. Thank you.
Thank you.
I'm guessing she practiced with a timer.
Okay.
Right in front.
Keeping us on time, I like that. Okay, next we're gonna go to, does anyone else in the room have testimony they want to provide?
Wait though, till it came late.
No, go ahead. Aiden, you're good. We'll do everybody in the room and then we will,
To be sure, is he aware this is a public hearing?
this is the public hearing for the permit review process. Yeah. Yep, thank you.
Well, hello, commissioners. My name is Aiden Espino. I live in Olympia. I'm also here on behalf of South Puget Sound Habitat for Humanity, which built permanently affordable homeownership. I am here to say generally that we are very supportive of, I think, the proposed changes that you're here to make, and I think in our view, see it largely aligned with necessary law changes from the state, but also, I guess, unfortunately coming to say that we generally like SEPA exemptions and sort of consolidating those processes. So, we 100% understand the public policy purpose for SEPA and community review. I think in terms of what's relevant for us in developing in the county, just generally, and I think for your process here is, while there's a nexus with SEPA for local projects in that community review, in terms of environmental impact, there's still a lot to unpack in the state buildings design code that all projects are still upheld to. So I guess my main message to you is, as you consider this, I don't know the specific circumstances in my review, what certain timelines or certain allowances would be. I think that's generally what limits SEPA or refines SEPA is generally on the path of good in our eyes in terms of development, and especially for the main purpose for the state. I guess what I'm saying is, with regardless of what you do, all of streamlining SEPA, making it easier on the local end does not inherently remove environmental consideration because of just other state policies, and especially regarding to building code, runoff requirements, so on and so forth. There's still such a plethora of requirements that our developments need to consider, and especially on the nonprofit end of things, where we're trying to develop that cost. A lot of the time that it takes to go through SEPA reviews, which is really a public input process, as Brett mentioned, it just adds cost into the lines of credits that we have to take out. So anyways, I hope that's helpful. That's what we're coming here to say is this is more about public input. So if you want to go faster, go faster that way. Thank you.
Thank you, Aiden. We're gonna go online now, and the first hand I see raised is Patrick Klein. Is that right?
Yep, I think so.
Mr. Klein, you are going to be made a panelist, and then you will be allowed to take yourself off mute, and you'll have 3 minutes to provide testimony.
Hey, good evening. Can everyone hear me?
Loud and clear.
Okay, great, thank you. My name is Patrick Klein. I'm a 23-year retired Navy veteran. I live at 8847 153rd Avenue Southeast. It's smack dab between Tenino and Rainier, across from Lake McIntosh. I'm asking you to preserve the public's right to appeal hearing examiner decisions to our locally elected county commissioners before those decisions move directly to Superior Court. Eliminating the local appeal will force residents just like me straight to the Superior Court, where legal costs are going to skyrocket and the examiner's ruling will carry a built-in presumption of correctness. Most neighborhoods, including my own, can't bankroll that fight. Well-funded developers can. Removing this step is going to turn fairness into pay to play. The elected county commission is charged with weighing the big picture policy, cumulative environmental impacts, neighborhood character, and long-term growth. Without this review, voters are going to lose a practical, transparent avenue to correct faulty land use calls. Shielding leaders from tough decisions is going to erode accountability. Without this safeguard, projects that chip away at water quality, wildlife corridors, and rural livability will advance more easily. Years from now, taxpayers will foot the bill to fix problems an accessible appeal could have prevented. Many residents already suspect the system favors deep pockets. Stripping away their most realistic path to appeal confirms that fear. Trust lost now will be hard to restore later. And this is going to look like a procedural tweak, but the stakes are tangible. Clean water, healthy ecosystems, and a fair chance for citizens to be heard. I urge you now to keep the local appeal pathway, preserve an affordable, voter-responsive check on land use decisions, protect Thurston County's future, and make sure our children inherit communities we can be proud of. Thank you for your time and your dedication to the community.
Thank you, Mr. Klein. The next name on the list that I see is Loretta Sepinen. Loretta, you'll be made a panelist. When that happens, you are free to unmute yourself and provide your testimony.
Hello, this is Loretta Sepinen, Olympia, Washington. Trying to get my video to start here. I am speaking tonight in opposition to the same two items that others have been writing to you about and speaking about. I am opposed to removing the Board of County Commissioners in the as a next step in the appealing hearing officer decision. But more importantly, I'm opposed to even having had that issue on this particular bundle, which is supposed to be minor amendments. On the website, this is listed under minor amendments. To the people, this is not a minor amendment to the people whose permit was turned down by a hearing officer. It's not a minor amendment to the people who think hearing officers get the decisions wrong. I ask you to turn it down. I know that this is the Board of County Commissioner request, so they're going to want to have it discussed, and they're going to want to have a positive decision out of this. I ask you to ask them to do it right, to put it on the 2026 docket, respect people's right to give their input to the county commissioners, and do the whole process right. So the second item I'm opposing is increasing the SEPA categorical exemption only in the rural area is my opposition. I am in favor of changing the exemptions in Grand Mound, but not in the most of the area that you're responsible for in the rural area. At your May 21st meeting, staff said, well, kind of the reason you're doing this is because of Senate Bill 5412, 2023. That they failed to mention two things about that bill. One is it is exclusively about the cities and the UGAs exclusively. And number two, it's permissive. It says may. It doesn't say that you must. So you don't have to do anything, but I do agree that you can extend it in Grand Mound. Okay, so think about when you sit here with your comprehensive plan hat on. What you have repeatedly said, and I'm right behind you when you do this, is that you want a much smaller percentage of future housing units to be in the rural area. You want 5% of all future housing units rather than 14%, much smaller. Okay, you want them in the rural areas. So to be consistent with your 5% goal, keep that plan, the comprehensive plan hat on, and don't increase the SEPA exemptions in the rural area. If you talk about this further, when I talked about the comprehensive plan, gave my input, I said we needed another docket item to really talk about the idea of the cluster development, because that's the one place where you talked about it and said, well, maybe we need that bigger exemption. But I think there's plenty of things we need to talk about cluster development. And so, because community absolutely does not understand what the benefits are or how it works or anything. So I want you to throw this idea into a docket item for next year. Cluster development, maybe there can be an exemption in there, but it should be part of a bigger discussion about cluster housing in the rural area. Thank you.
Thank you, Loretta. Next on the list, I see Lisa Reiner. Lisa, you will be made a panelist. And when that happens, feel free to unmute yourself and provide your testimony. Here we go. What's happening? Here we go. Oh, got it. Lisa, it looks like you've unmuted yourself, Lisa, but we can't hear you yet.
Lisa is still in attendees. Claire has been moved into presenter.
I see.
Oh, wait, she's in both.
Yeah. We still can't hear you, Lisa, but it appears you're unmuted. Oh.
I've given her permission to speak.
Lisa, you'll need to accept the move to a panelist. Provide testimony. Do you want to go to the next person on the list and then give her another chance after that? Okay, the next person on the list, I see a name. Pardon me if my glasses don't allow me but to read the name correctly, but I think it's Isha Alexander.
Maybe Aisha.
Aisha, apologies if I'm getting the name wrong, but you will be made a panelist. Please unmute yourself and feel free to give your testimony.
Thank you. Can you hear me?
Loud and clear. Thank you.
Thank you. Good evening, commissioners, and thank you for the time that you volunteer in this position. My name is Isha Alexander, and I reside at 8735 153rd Avenue in Tenino in Thurston County. In regards to removing the county commissioners from permanent appeals, please keep the ability for citizens to appeal hearing examiners' decisions to the Board of County Commissioners. Eliminating this step forces appellants straight to the Superior Court, where the cost to pursue appeal and the starting assumption that the hearing examiner made a valid and accurate ruling makes the reversal nearly impossible for your average appellant. The Board of County Commissioners exists to weigh broader policy considerations, cumulative environmental impacts, neighborhood character, and long-term community goals. These are considerations that a technical land use ruling may overlook. Removing the Board of County Commissioners review shelters elected officials from hard choices, but also strips voters of a practical, transparent avenue for accountability. It tips the scales towards the deep-pocketed developers and weakens environmental protections in Thurston County. Leave the Board of County Commissioners appeal in place so residents still have an accessible, democratically accountable check on faulty or one-sided decisions and can safeguard the county's future. Second, I strongly disagree with the increase of SEPA exemption thresholds. The proposed increase in the number of residential units exempted from SEPA review from 4 residential units to 20 for developments outside of UGAs will not ease the housing crisis for those that need it most. What it will do is put water resources, forests, and agriculture at risk. The SEPA process is critical for analyzing and disclosing potential impacts to the natural environment, and the 5-fold increase will substantially reduce the ability to analyze cumulative impacts, which may result in significant impacts to critical resources before they're even recognized to be a problem. Please remove these major policy changes from the minor amendments list and put them on a standalone docket to allow for proper public review that these proposals and their impacts should be subjected to. Thank you for your time.
Thank you. Yeah. Next on the list, I see John Newman. John, you will be made a panelist. Please unmute yourself. You'll have 3 minutes to provide testimony.
Yes, thank you. Can you hear me?
Oh, yes, loud and clear. Is this Lisa?
Yes, this is Lisa. Thank you very much for your patience. My other computer didn't work, so I'm now on this one. Essentially, I would like to repeat what has been said often tonight. Many of us are discouraged about what has been discussed. Insofar as the Board of County Commissioners actually themselves put forward that these decisions after the hearing examiner would not come before them for them to discuss and decide how to go forward or not, but these decisions after the hearing examiner would go directly to Superior Court. Many of us in the community wonder why the Board of County Commissioners would make this decision. It doesn't make sense to us. Many of us, of course, love our democracy. We love being able to fully understand the very difficult environmental problems that may arise with a faulty decision. Many of us do not have money to go to Superior Court. We have no money for lawyers. And for the Board of County Commissioners themselves to address this and to bring this forward, this idea of going straight to Superior Court does not make sense. I see so many of us involved in electing of county officials and city officials and state officials that have our trust. What does that mean to have our trust? That means they're accountable to the citizens of the county, the citizens that help them get elected, the citizens that are looking to policy and policy changes. And what does trust mean? We want to hear from the elected officials, and to go straight to the hearing, from the hearing examiner into Superior Court erodes that trust completely. So I just don't understand why this has been put forward, and maybe we will find out in the future. But thank you very much for your patience with me and my computer. Thank you.
Next on the list, I just see a name, Observer. But when you're made a panelist, please unmute yourself and state your name and address for the record. You'll be in 3 minutes to provide testimony.
Hello,
Hello,
can you hear me?
we can.
Great. My name is Tia Gulbranson. If you need me to spell it, I can do that. I live at 8505 153rd Avenue in Tenino. I would just like to voice my opposition to rerouting the appeals process. That appeals directly go to the Superior Court and not first the Board of County Commissioners. This is a pretty significant change, and having the BOCC review, that's what the Thurston County residents need first to address their concerns locally. Removing it reduces the public's voice, and the public relies on that as an accessible and local way to voice concerns. Removing that step only makes it harder for the public to participate and also limits the board's ability to hear from the people that they represent. I'd like to also voice my opposition to the SEPA exemption in rural areas. We need SEPA, and it exists for a reason. It evaluates environmental impacts before decisions are finalized. Rural areas, such as where I live, usually have sensitive habitats and unique land and water considerations that make environmental review even more important. There's limited infrastructure and compared to urban areas, and SB 5412 was clearly being aimed at urban infill and not rural development. So including this change risks long-term harm to our communities. Additionally, I would like to emphasize that the annual review should both support the public as well as internal operations, and changes that reduce public access or limit environmental oversight shouldn't be fast-tracked through a process meant for routine updates. These proposals are too impactful to be categorized as minor, and I urge the county to give them more thorough and transparent review that they deserve. Thank you.
Thank you, Tia. The last name I see on the list is Kyle Gulbranson.
Can everybody hear me?
Yes.
Good evening. My name is Kyle Gulbranson. I reside at 8505 153rd Avenue Southeast in Tenino. I would like to voice my opposition to removing the BOCC from the appeals process. The BOCC's purpose for the appeals process is not so much a stopgap, but a midpoint for your local citizens who may not have the funding or the backing to pursue and file and deal with attorney's fees and lawyer fees and court fees that would be required in a Supreme Court appeal. The BOCC should be and should always remain in that position. That way as they say, little guy has a voice. I would also like to oppose the SEPA exemptions. SEPA is there to protect not only us, but the environment at large. The environment at large does not get a say in what we do to it, so we have to stand up for the environment itself. There are many, many layers to the environment, as you all know, and we have to have a voice for it. That voice should be the populace. We should have the reviews done, the permitting, and everything else. Thank you and have a good day.
Thank you, Mr. Gulbranson. I don't see any other hands raised. So I think we will close the public hearing on the planning review process update, and we have comments.
Are we on the?
Oh, I guess.
Process, or are we still?
Yeah,
CIP and.
How do we want to?
On a public hearing.
How do we want to do the rest of our, I'm asking the commissioners, how do we want to do the rest of our agenda? Do we want to go back to work session 1 on the capital improvement program update? Or do we want to do the permit review process right now while people are still listening?
Be the most respectful of the folks who came out here or who are sitting online for the public comment. If we're going to respond to it directly, also, just personally, I know it's going to stay in my mind a little bit.
I agree.
We got 2,
I support that.
3. Okay, I think we are at agenda item 6. The work session on the permit review process, annual update.
I do not have a presentation. I think it's worth noting that at the last work session, you all chose to leave the number 20 units in the hopes that you would get public feedback to guide your decision, and we were successful in that. I think that's great. I also think it's worth recognizing that we probably fumbled a little bit titling our webpage minor amendments. This was an individually docketed project. All of the items that are on that page, minus the countywide planning policies, which is included on that website, are docketed items. So I recognize and I hear the community saying that this isn't necessarily minor and that we should have some internal discussions on maybe amending that webpage title. However, the official docket names are listed on that website.
And we did go back and check to make sure that the docket project sheets that were prepared had descriptions that encapsulated, you know, everything that is in the package before you. And the appeal one in particular was called out as a, you know, a separately listed docket item that the board discussed for those commissioners that followed the docket process.
Okay.
I was going over the question and answers that we got for the public comment from I believe it's from the Southside Bird Alliance, which would make sense given public comment. It says under question 7 that SEPA review is not triggered for all proposals by occurring within covered. This is about like whether like protected species review is still happening if the general the SEPA review is not. So it says that it is not triggered for all proposals just by occurring within covered species area habitat. Categorical exemptions to SEPA still apply. I guess I was just checking about what categorical exemptions to SEPA still apply means in this context. If we're talking about protected species, I have a follow-up question too.
So if a proposal exists in a critical area, that alone does not trigger SEPA. And so if it's in a critical area and we have a categorical exemption, then that threshold applies. Just because it's in a critical area does not mean that we do a SEPA review. We have critical area review permits. We have other things in our critical areas ordinance that we have to adhere to. But SEPA review itself is not necessarily part of that process every time.
So all the environmental protections that are baked into the critical areas ordinance apply. So we rely on the, you know, WDFW's information, PHSS list. And so any endangered species or protected habitat identified by them would have to go through a rigorous process of review by a qualified professional that then gets reviewed by staff. A lot of these do end up with the hearings examiner if there's any kind of impact. Through a process called reasonable use exceptions.
And then I was curious just in terms of like actually that does now that I think about it, that doesn't answer my follow-up question, which is about like what happens when, as seems to be the case, federal protections disappear. But like it sounds like that would be covered, yeah.
It's a relevant question. So we have an approved habitat conservation plan, which is tied to an incidental take permit, but that does.
Sorry, I can't really hear. I've got too much noise in the background.
What that incidental take permit does is provide certainty. So as things shift at the federal level, like we still have that permit. That permit covers the protected species and endangered species in it.
There's no way around the ESA.
Not at this time, or our HCP. So our HCP is something that we implement under that incidental take permit. So US Fish and Wildlife is counting on us to implement it as they approved it.
The state is also currently undergoing rulemaking to backstop some of the federal regulations that they expect to be less toothful.
And in addition to the HCP, we also have all of the protected species and those, and the habitats of those species identified by the state.
So I guess my follow-up to that is, it sounds like there's a lot of different experts who are weighing in on this, which is great. It does sound like, it does seem a little burdensome as, especially if we're talking about affordable housing developments. But like, I don't see a way around providing public input in a way that isn't as expensive as a court system is. And I'm wondering if there isn't something around exemptions around nonprofits and low-income housing that would be, like, it seems like there's just a lot of room for finesse in this that like would be really useful. That when we're talking about not what nonprofits are trying to do, when we're talking about what low-income housing wants to do, that shouldn't be a shield for these other developers, which are the ones that people are writing and concerned about. Like, I don't think any of the folks, the many folks from Tenino, I think this is the most I've ever heard from Tenino. I don't think any of the folks there who were speaking against developments had an agenda against Habitat for Humanity. You know, like, that's not who they're speaking about. And I think that we should be able to make that accommodation in the law and the code.
Number of comments. First is just a point of personal privilege. I was unaware of Sudan versus Bassett. Sorry to hear that. I wonder if we should make a motion to make her an honorary member of the planning commission. She and maybe Betsy and Loretta and Christy White have been, I think you've said it, Commissioner Casino, honorary members for a long time.
As long as it doesn't throw off quorum.
Yeah. So sorry to hear that. Question for staff. Have you usually with the large number of comments, you have some kind of categorization like X% for, against, opposed, in favor, et cetera. Do you have any of that analysis, or just barely got all the things?
We did not do a sentiment analysis with the survey. We really only used that in docket, and we found that the AI was a little bit skewed. I mean, the big themes of the comments we got are keep the board in appeals, 20 outside the UGA is too high. And then there were a handful who had strong opinions about the airport. And we could kind of disregard those since that's not our jurisdiction.
That's what I was asking next.
But, and then that wasn't the third one. The third one is actually that these things should be pulled out as independent docket items. Those were the big three themes. And besides Aiden speaking today, on the whole, they were all in opposition to the appeals in the SEPA threshold of 20.
Every comment was negative towards the removing the appeals to the.
What I read.
Yeah, all 47 pages.
I did read all of the comments in the minutes, so I can say that with confidence.
So we have previously as a body made motions to say that we want to recommend that the Board of Planning Commissioners should remain in the process. That's noted for the record. So we don't need to do anything more on that. But is the questions about the SEPA exemptions and the questions about the building projects exempted from SEPA review. It feels like we need to do something if we care about those issues, and I do. So maybe we should discuss, or maybe we should make a motion, but it seems like that's outstanding issues for us on this.
I agree. Just want to see if anyone who hasn't said anything. Okay. Bombarder.
I just gonna echo that we are a citizens advisory committee, and every citizen who's contacted us has spoken pretty strongly against cutting out the BOCC.
And many of them eloquently.
And very eloquently and timely, with incredible rapidity and not a lot of filler words. I get very conscious about filler words, my ums and uhs and whatevers. I would also state, like, I don't most of the SEPA exemptions, I don't think are a huge focus, but things like allowing 40 car parking lots, there's no distinction on that, whether in or outside of UGA, so we can just pop up permit-free half-acre parking lots anywhere in rural county, like,
That's what title it's in.
it's frustrating. I don't have an issue with most of what's happening here, and just to put into context, we think about like storage and warehouse and commercial things, like 30,000 square feet is like an acre and a half. It's not a Amazon warehouse or something like that. It's easy to get those numbers anyway, but yeah, I don't think the SEPA exemptions are finessed properly yet. I think a lot of what's in there is fine, particularly the stuff within the urban growth areas and the ADU stuff, but I think it could use a little more work.
I can leave one note. See, the SEPA threshold changing doesn't eliminate any permitting that would be required. So even if these thresholds weren't touched at all, they could still happen potentially. They would just be required to go through a SEPA process. And so even if we raise the threshold to whatever number you all choose for these items, they still have to go through the permitting process, which has additional review and environmental considerations as well. It's just whether or not they have to go through the SEPA checklist, determination, legal noticing for that, noticing out to the community and those things in the specific SEPA way. They're still noticing things that are required for permits.
My main concern with parking lots anywhere is it's a huge impermeable surface, and one of the main checks I would want there is an environmental check.
Well, we have impervious surface restrictions in all
Yeah,
of
and
the,
there's the drainage design and erosion control manual that gets applied, all the stormwater design standards, all the zoning and land use standards. I think what the state's been trying to do with introducing different exemption thresholds is in recognition that most jurisdictions have adopted all of these other plans, all of these other codes and provisions that get applied through the development permit process.
I guess one other question, this details multifamily residential structures in rural county. We don't have a zoning category for multifamily in rural county, do we? It just seems like a weird thing to throw in there when they don't exist.
We just, when we were updating it, we were looking at what is identified in the WACs for unincorporated areas.
But what's permitted in the,
No, and for consideration. So it,
yeah, it just the way it was phrased made it sound like the WAC was dictating that we permit that when it's allowing that.
yeah, sorry if that was confused, just recent changes in state law, sort of prompting a look at this. And once we looked at it, we realized it hadn't been touched since 1999. And so we're like, oh, this is what the WAC says now for what can be considered by cities and counties that are looking to even change what the thresholds are. But it's optional, so that's why we're having a conversation about it. First time this group has had a conversation since 1999 about it.
Wow.
you had a comment.
Forgive me, but I forget that one. I don't recall that 99 discussion.
Probably find it.
I don't know if that was a guess but and what else would be included, but a 30,000 square foot building would be 3/4 of an acre. Actually, just under. I mean, it'd probably have other stuff would be associated.
Plus parking for 90 works out to 1.46 acres roughly. That's why
And I think, the other thing I was gonna say, I think we've had a lot of discussion about this and we have made our position clear, but I think because it's here, we need a motion on the appeals process.
Is there?
And so I would offer a motion that we recommend no change to the current wording of 20.60.060 appeal procedures.
It's been moved and seconded. Any discussion?
I guess my discussion point is, we are essentially submitting a recommendation to a body that has requested something.
Yes.
So that it can decide whether it wants to give itself what it asked for. I just wonder if there is a way to make this more difficult to dismiss by the BOCC than a simple recommendation against. I'm not sure what that is.
There's one clarifying thing I can add. The appeals is in more than just that one section. And so I can specify that in the motion, in the recommendation letter, so that you all don't have to comb through. But I just wanted for the record to know that it's in more than just that one section. And I'll reflect that in the recommendation letter.
Yeah, that's fine.
Commissioner Bartlett.
I just want to check that we don't have a motion on the table, or are we still
We
discussing?
do, it's moved and seconded, so we're discussing the motion. I think we've just accepted a friendly amendment to include all the sections of the code.
I guess what I had been wanting to point out was that while there was overwhelming consensus against changing the SEPA review process on a lot of these issues, there was actually a lot of consensus around the idea of like allowing less review in the urban growth areas. And then also just for lower income housing.
Let's hold that until we've taken a vote on the motion. It's on the table, okay? But I'll come right back to you.
Okay.
Okay.
Can I hear the motion again, Scott?
Yeah.
Yep, my motion was to make no changes to the current language of appeal procedures. Which would include 20.60, 0.060, and whatever other.
So is that the same as option one here?
Option one approves it. I think it's option
There's
two.
no changes to public hearing draft.
So wait, that's,
You're asking for a change to remove sections from the package.
Yeah, so option three does not meet the request of the Board of Commissioners. That's to remove the appeals process amendment. So,
Okay.
but they package these three things together when I think we sort of want to build our own based on those three items.
More?
Yeah, I was just gonna say, this contains changes both to the appeals process and the timelines. I didn't hear people complaining about timelines. I heard them talking about not being able to talk to the BOCC, and I just wanna make sure that what we're proposing doesn't interfere with changes to timelines.
Yeah, the permit review timelines
Those are in.
themselves there were no comments on those, and that's
I
separate
just
from
wanted to make it
removal.
clear that when we're saying the permitting process, we're talking about that step to people.
Appealing hearing examiners' decisions to the board as
Yes.
opposed to the permit review process.
Just something
Seeing
worth
nods
clarifying.
that that's what we all understand we're discussing, okay. Any other comments on the motion? Seeing none, do we wanna call roll on this one?
I can use that.
I think the voice vote would be.
Yeah, okay, then all in favor?
Aye.
Any opposed? Okay, terrific.
Bill Fishburne on my.
Oh, Commissioner Fishburne. I think that was an aye.
That was an aye.
That was an aye.
Okay, terrific.
Unanimity
Terrific. Okay, that motion passes unanimously.
again.
Yes. Thank you. And Commissioner Bartlett, back to you.
okay, yeah, I guess if we are talking about amending the SEPA review process or being more specific about it, being a little more finely tailored, I think low hanging fruit in terms of consensus is restricting SEPA review exemptions to the urban growth area. It also sounds like we could do something about that around like low income or nonprofit housing. If we could be that specific, I don't know if we can.
How do other commissioners feel about the distinction between urban growth area inside, outside? And was there a motion that we want to, something we want to carve out?
Yeah, trying to figure out if I want to phrase this positively or negatively. I propose limiting the SEPA review exemptions to the urban growth areas.
Limiting the changes.
Limiting the amendments to the SEPA categorical
Yes.
exemption threshold, so removing any thresholds that touch the rural area.
Yeah.
Removing any updates.
Yes.
Because there's already
Yes.
stuff in there.
Yeah.
If I could.
Yeah.
Could I suggest that
Please.
we say not ones that impacting the area, but ones specifying because we have a couple universal things and those changes aren't very significant. It is very particularly, it's the ones that specify the urban growth areas. Like, we don't make a distinction on ADUs in our things. We don't make a distinction on a number of those items on there. And so it's not as easy as striking the ones that impact the unincorporated county. I would say it might make more sense to focus on the ones that specify the unincorporated county, because that's where that 20 housing or 35 multi, and then the large parking lots and large lots in that, sorry, that's called signed.
You're saying where specified, or where urban growth areas are specified in the code, we would be limiting.
Stick with original language.
Yeah, limiting to original language. Wait.
Is one way that we can parse this to say that where in talking about within the urban growth areas, we can, you know, take a vote on whether we like the changes or not, and then we could talk about outside the urban growth areas separately.
Our packet already does that. So I think the question would be 170905 on page 2 of our packet. Thank you. Letter B, outside an urban growth area, construction or location of any single family residential structures of 20 dwelling units or multifamily residential structures of 25 dwelling units. I think that's the question we're looking at. Yeah. And I don't want to speak for everybody, but I'm fine with leaving the urban growth area the way it is.
It really does seem like it's only item B that we're B and perhaps D where we're.
The new sentence in D and the changes to B. So if you wanted to exclude the updates for those two subsections.
So it would exclude it would exclude the in an urban growth area and 12,000. So we'd remove the and 12,000 square feet of gross floor area or less and associated parking facilities designed for 40 or fewer automobiles outside an urban growth area. So basically the comma after growth area becomes a period and everything beyond that gets stricken. And the language in B reverts to its original 4 units.
What page are you on?
We are on page
2 of 80.
The big,
Oh, okay, I'm on the
in
wrong
that
page.
little
too.
summary.
I was on the wrong page too for a while too.
Yeah.
That sounds like a solid proposal.
That way we're more specific.
Yeah, I like that.
Would the planning commission mind making the motion a second time, given the discussion that's.
You want to make it again, or do you want me to do based on what we just said?
All right, you can make it because I'm
Okay.
not quite there yet.
Motion to
I think we should do them individually.
move to recommend 17.09.055 categorical exemptions be approved with the amendments that the changes in B be reverted to its original language and the additions to D starting after the words in an urban growth area at the end of it be stricken.
And it sounds like Commissioner Nelson was requesting that we break those two up. Am I correct in hearing that? Okay. So can we maybe do a and then B? Vote?
A and then D.
Or A and then D, sorry, yeah. Or B and then D. B and then D. Yes.
There's a motion on the table. There's not been a second, so we can.
Second.
Okay. Any discussion or amendments that you would?
I just realized because the original language in D didn't specify within an urban growth area and without, we almost need to split D so that the previous language still applies to outside of the urban growth area, which would be 8,000 square feet for office, school, commercial, recreational, service buildings. If we do it the way I proposed, it would technically not allow any exemption outside of a urban growth area for those. And I think the 8,000, which is the current one, makes sense.
Parliamentarian, can he
I'm just-
withdraw his motion after it's been seconded?
I can amend it.
Okay.
Anna, how, help, how would I fix that?
I think maybe I would recommend splitting it in two, and the motion, like having a motion for item B, revert it back to what it was, which is 4, leaving it at that. And then item D,
Let's workshop it.
yeah, item D needs workshopping, but we can move forward.
Let's get one out of the way.
Okay, sorry.
So.
I'm amending my motion to just be the part in B. So just reverting the language in B, to revert it to its previous language.
The existing.
The existing language.
Does it still need a second?
Yes.
Yes.
The amendment needs a second.
A second amendment.
The motion has been seconded, the amendment has been seconded. Any discussion of leaving section B, section B, excuse me, as with the existing language and not recommending the updated language?
Can I just, are we still in discussion?
Discussion, yeah.
I want to make sure that it says outside an urban growth area, construction location of any single family residential structures of 4 dwelling units. That or multiple residential structures of 25 dwelling units does not come in.
The single family was an addition.
Right.
So
So to just say residential structures of 4 units.
New residential structures.
is it worth specifying single family versus residence alone?
I think it is.
Yeah.
So you're
Only if we're using different numbers for them.
Well, we aren't using any numbers.
We're using
for
the
'em.
same number for everything, then we don't need to specify which is which. Right?
Well, we're outside the urban growth area, outside the UGA. Do we want any multifamily residential structures outside the UGA? Which would be in the rural area.
You could, I mean, this would still, I mean, this would just apply to structures, right? So this would say 4 units, so you could build a 4-plex without having to get a SEPA. If you wanted to build 2 of them, you'd have to go SEPA. If you wanted to build 4 houses, single family, no SEPA.
Yeah,
5
no, I'm
houses,
just saying,
SEPA.
what it says to me is, are multifamily residential structures of 25 dwelling units. That's not what we want.
that would be stricken.
No,
that's
stricken.
Yeah, anything that's blue in that or underlined would be stricken. So it would read outside an urban growth area, construction or location of any residential structures of 4 units.
Okay. Yeah, that's fine with me. Makes more sense.
It makes sense to clarify multifamily in it anyway.
Are we ready for the vote?
I think 4 is pretty low. I mean, we're upping the thing we're upping, and this isn't, you know, are you compliant with critical areas? This is a SEPA determination. And I think that's a pretty big step if you to have to apply for SEPA.
What do you think the number should be?
Well, let's see. Based on the other things I'm seeing, maybe 8.
Okay, would there be an acreage attached to that?
No.
You would still have to meet underlying density requirements. You know, we've heard public comment, we've been talking about as part of the comp plan cluster subdivisions. And so that's maybe something we've discussed previously, setting it at 8, you know, mean, Commissioner Pressing even said maybe 20 for clusters, but that was a discussion at the last work session of taking that into consideration with that threshold.
Probably changed my mind after hearing public comment.
You could still build a clustered housing with a SEPA.
Yeah, it's not preventing it from happening. And in fact, that would strengthen it happening. Yeah, do we, so the proposed friendly amendment is keeping it the same except changing 4 to 8?
Only the maker of the amendment
don't
can
know if
determine
it's
if it's
friendly.
friendly or not.
Well, that's why I said proposed friendly.
I think it's worth voting on it the way it was proposed.
Okay. All those in favor?
We should probably voice vote. It sounds like we'll have dissent here.
Okay. Yeah, would you like to call the roll?
I can call the roll.
Okay, cool.
Commissioner Casino,
Nay.
Commissioner Bartlett,
Aye?
Commissioner Nelson,
Nay.
Commissioner Kaiser. Nay. Commissioner Bumbarger,
Aye.
Chair Hanson,
Nay.
Commissioner Miller. Aye. Commissioner Pessinger,
Aye.
Commissioner Halverson,
Nay.
Commissioner Fishburne, excuse me.
Aye.
We are tied.
Yeah. I would entertain motion to do that again with changing the numbers though, if somebody wanted to make that motion.
So changing it from 4 to 8, is that?
I have a feeling.
They'll end up with the same result.
You think so?
Yes. I don't know. No,
I
it
don't know if it
appears
would or
Commissioner
not.
Casino may be in favor if it moves to 8.
I guess I meant to say it'll be the opposite result, which is the same.
If that's the case, what would be the number between 4 and 8 that you think would get there? Here we are.
Okay.
If I could, most developments in the rural area come in as 6-lot subdivisions. Because of, well,
Okay.
Yeah.
All right,
Words aren't coming.
But it's like a family size package.
So then the number would have to be at 7 before, or the SEPA exemption would come in at 6 units?
It's just information about how.
It's a theoretical.
There's also a question there about what kind of development you'd see and what kind you're incentivizing. So those come in because they're exempt to certain, basically water right necessity. And is that the kind of thing you want to make easier, or do you want to make it easier for people who are gonna go the extra mile and like get water right?
Yeah, given that, I would want to, my suggestion is to remove all of the edits for B except for, and then change 4 to 6.
Is there a second?
Second.
Okay. Any discussion on that? Call the roll.
Aye.
Aye.
Nay.
Aye.
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 Aye. Mr. Fishburne?
Aye.
Okay, that motion passes and we still want to address section D. So the concern was that there wasn't, if we did this, there would be no way of addressing areas outside the urban growth area if we just strike that.
I think I have an idea on how to do that.
Okay.
I propose that we split D into 2 items. It is too long as it is, and it's difficult and unwieldy for the public to understand. The first of which would say, outside of the urban growth area, the construction of an office, school, commercial, recreational, service or storage building with 8,000 square feet of gross floor area and associated parking facilities designed for 30 automobiles. So basically the old language, but it's saying outside of the urban growth area. And then the new second item would list the amended language ending at the urban growth area. That way we would maintain current rules for the for outside of the urban growth area, but permit the new language within an urban growth area. So that is my motion, or my.
Second. Okay, there's a motion and a second. Any discussion? I'll start by saying I think that addresses pretty clearly the comments we heard about this item.
I believe it does.
I think, and at least that's the intention, and that's the way I'm interpreting what the motion is.
Cool.
Any other discussion? We want to take a vote.
Okay, just so, again, I just wanted clarification.
Mhm.
Okay. What we're talking about is the first part of that, being within the urban growth area, the construction of an office, school, commercial, recreational service or storage building with 30,000 square feet of gross floor space or less, associated parking facilities for 30 or fewer automobiles.
Outside the urban growth area.
Still, all of the new proposed language would be in effect only for within the urban growth area. Right,
Okay.
so D essentially, up to that point where it says within an urban growth area,
Yeah.
becomes a new second item. And the original language stays in place for outside of the urban growth area.
Gotcha. The addition that
I'm not.
I think there might be a little confusion. That first section, the 30,000 square feet and all of that is for within an urban growth area.
Correct.
Yes.
And that would stay
You
as
were
a
saying
new
the
item.
opposite.
No, so this becomes two items.
Yes, I'm following that.
The first one is the old language.
Which is, the old language is for an urban growth area. That's the point I'm trying to make.
The old one does not specify within an urban growth area.
That's the intention of that section of code though, which is why it was added.
But we're clarifying. So you're saying in the old
So you
language is
want
intent.
outside of an urban growth area for it to be 8,000, and then you want inside an urban growth area to be the new language.
Yes. Right.
That was what I proposed. I did not realize that despite not being listed in there in any way, the old language somehow did not allow this outside of the urban growth area.
That's why I wanted clarification.
Because it doesn't state that.
Well, it kind of does on the back end.
Yeah, because it's like, if otherwise, if we don't mention urban, outside the urban growth area at all, it remains, yeah.
I understand that we have added within an urban growth area to this. If I'm understanding what Anna said correctly.
We don't need to.
Well, if I'm understanding what Anna said correctly, the previous language, despite not stating anywhere that it only applied to an urban growth area, only applied to an urban growth area. Is that correct?
When we look at our code and recognize the time it takes to update the code, staffing restraints and whatnot, a lot of our code is outdated and confusing and contradictory, and we do have to look at the intent behind the code itself. So I think, I don't wanna go on record saying explicitly what you're saying, but I do wanna go on record saying in 1999, when this was proposed, I believe the intent was recognizing that it was for in urban growth areas as opposed to the rural county.
So if I'm understanding what you're explaining about the intent, if we were to, as I initially proposed, simply strike the language from the end of this that speaks about outside of the urban growth area, we would be sticking to the previous intent of this exemption?
That it would only be within UGA.
Okay. Okay. I retract my previous motion. And I would
Because
like
yeah, and then, because the important thing is like subsection C really speaks to natural resources, natural, like buildings associated with natural resource uses. And so I think as long as that one is there, so our ag operators don't all of a sudden have to do SEPA to put in a new barn.
I don't think anyone's suggesting a change to.
Not a change to C at all.
Yeah, I know, but that's why I'm saying, like, I think it's fine to have the commercial structures that we're talking about in D be more limited, as long as you've got an allowance for folks who are in the natural resource industry to still build barn.
Okay, so I would like to reintroduce my first motion on D, which simply strikes everything after the words in an urban growth area from D.
Seconded.
All those in favor?
Aye.
Aye.
All those opposed? Okay, well done.
Please never make me do that again.
Mind if in my recommendation letter, I say that the motion was to, and then I specifically list out exactly the code that you all want.
Yeah,
That's fine.
please.
I think that might be a little clearer than the verbatim.
Which is why we went item by item anyway, to make it clear, because giving you vague instructions about what we'd like leaves a lot for you to interpret, and we don't want to put you in that position.
Okay, is there any further discussion of the permit review process annual update?
I have
Commissioner
just a
Pester.
comment.
Well,
Oh,
I'll come right
sorry.
back to you,
Okay.
Commissioner Kaiser.
I move to maintain the ability to appeal the planning director's decisions for unclassified uses.
Second.
For those that aren't looking at that specific provision, and then I looked and it was unlike all the others that called out the appeals either to hearings examiner or Superior Court, or I'm sorry, hearings examiner or the board, this one combined them. So there's a table that said it was hearings examiner, but then the actual narrative language, it's combined. So the table still had it in there. I think it would make a lot of sense to clean it up and just say it should be hearings examiner. Anything that the director does should be appealable to the hearings examiner before you would go on to any other step. So we'll just make sure that it's consistent, that the table matches the language.
It's not actually a code change where it's just a general language cleanup.
It would be an update. It's gonna be an update to like 3 sections. So not sure. It's the
2007
recommendation
of
letter
60,
can identify.
2027 020 and 2028 020.
I think in this case, it would be a motion to share the intention that
This table?
that table has it on there as an A for
Like
appeal to
54?
hearings examiner.
Of 80.
It is.
29.
It is, it'd be important to say that you want the table, or actually, we should check to see if by just eliminating the language, you refer to the table, and that way you don't have this
Yeah.
double reference, because what the language that's there now
Tables
isn't.
that look similar.
It doesn't match the table.
Yeah,
You.
Yeah, actually, removing all of the language means that the table would stand.
29 of 80.
so actually, are you suggesting affirmative amendment to my motion?
I would say that you might not need to do anything. We have eliminated the confusion with the narrative not matching
Okay,
what's in the table.
okay. Doing nothing is awesome.
So you're retracting your motion?
Yes.
Mr. Kaiser.
A pass.
Okay,
I just,
yes, Commissioner Holmes.
just for clarification, are we referring to the table on page 29 and page 41?
That table exists in 20, 21, 22, and 23. Our code is redundant. And so each of the UGA codes has its own table that is not a complete copy and paste, but it's the same table that gets at the same things of what happens where and when.
And to be clear for folks listening in, the line item in the table is other administrative decisions, code interpretations is how those things get submitted. And so the table says A, appeal to the hearings.
By doing, yes, Commissioner Messier.
The large number of comments we've received here that are almost in unanimity in their intention. And they don't usually get automatically forwarded to the BOCC, but I think in this case, it would be very worthwhile if they were. When it comes around to their docket a year from now or more. Is there a way to request to have all of these comments submitted to the BOCC when this is as part of our recommendation?
They already are. All of the comments that throughout the lifespan of a project are taken to the board for their consideration. That's standard practice.
Okay, great.
I think our recommendation, just given the conversation here, would want to underline the unanimity, senior unanimity of the comments in this regard.
Factual. Okay. Going once. Advice, okay. We are going to go back to item 4 on our agenda, which is the work session on the capital improvement program update.
You wanna make a recommendation?
You gotta make a.
No, we need to make a recommendation to like send our
To
packet.
send the whole thing with the amendments, thank you.
So you're moving to submit our recommendation as discussed.
Yes.
I second that.
Okay, it's moved and seconded, all in favor?
Aye.
All opposed?
Let's go.
Thank you, Scott.
Might be the easiest motion I've ever made. I've been so moved.
Yeah, thank you.
Did Commissioner Fishburne give an eye?
Yeah, you did.
He did.
Okay, perfect. Okay, well, thank you, everyone, for your efforts there. And we're gonna go back to capital improvement program, and Anna will give you as much time as you need to get back to where you were and out of one project and back to the other.
You can't see. Little clustery with papers over here. I also had to ask Natalie to get my laptop charger because my laptop's on the verge of dying. So if this goes away, I apologize. Really, this is intended to just be a discussion. The visual is an additional benefit, but we can move forward without it. We left off here with past issues and things that we're trying to address. Here. Yes, okay. Scheduled to date, like I said, Andrew's not here. He's really been spearheading this process in partnership with Public Works and Central Services in developing this new shorter template. This is the process that's gone so far. We've drafted it. It is still a draft. Like I said many moons ago, I think there's still a lot of work that can be done to make it a better community resource, and we're hoping to get some insight from you all into how that can be done. But this is just where we are right now with things. Like Ashley said, this cycle, it still has to go through the same process that it has before, but after this, when we shift to a every 2-year cycle, a little bit more involvement and a little different adoption because it would be explicitly tied to the budget. Okay, so we've gone through just kind of how we got to where we are now and things that we're hoping to glean from the conversation today. We've identified some changes, as you all are very well aware, the CIP looks different, it's shorter, and it's essentially a totally different document. The first one being that it's simplified for the sake of increasing staff efficiency and also public usability. The old one was long, it was a lot of pages. The financial chart included a lot of historical data, future data, and then the extensive project pages, it all just was an incredibly high level of staff effort. I shared this with a couple of planning commissioners last week. Up until this point, last year, I had spent 67, 70 hours just prepping the CIP to come to you all. And this year it's been a third of that. And that's just me, and I don't even have the hard part. Really, it's Public Works and Central Services figuring out what they're gonna do. And they've indicated it's been a much more streamlined process for them as well.
And to be clear, that time isn't spent like on substantive policy research or analysis. It is literally just collating information from other existing plans and trying to get it into a document and align it with budget. We're gonna go fast.
again, if this dies, it dies, and that's all right. Yes, so the proposed CIP, it, like I said, streamlined, and we're also highlighting successes of each of the groups, which was not the case in the historical CIP. Another change, the location of the project information. As I mentioned previously, we're hoping that this improves public communications as well. It was a long document and each project had its own page, but by the time the CIP is adopted, those project pages were a little out of date because this is, it's a planning exercise and that things change as revenue sources are identified and feasibility of projects comes to fruition. And so this proposed method, we have a separate webpage that allows for live updates and greater transparency. We can walk through that if you all would like at the end of this. I could probably pull it up on that computer to show you the example. It does link out if you've looked at the CIP on your computer. Public Works has a page where they update all the things that they're working on, and it allows for, like I said, live updates as opposed to the CIP project.
Now,
Have to.
is the idea for every entity to have its own site for those, updating those projects? Or is it all gonna be under Public Works?
Public Works has one, and we're hoping Central Services will mirror that. Like Ashley said, we're like having conversations so that it could live in one place. But I'll put this to you.
Oh, yeah, no, I mean, that is the vision, that it lives in one place. We have a new director of central services who is very interested in improving communications with the community on projects that they're working on, both internal to the county as well as externally facing. So that is the goal. Whether we're able to get there by the end of the year is questionable. But yes.
Just looking at it from my point of view and going to that website, yes, there are a few projects listed there, but not very many. And only really for Public Works and Water Resources. And so if all of the participants are going to do something like that, I think it's a great idea. I think it would cut down and it would be something that they could update routinely and continuously instead of every year or every 2 years when a CIP comes due. But that's not gonna help us this year.
It isn't. This year, we're in this like bridge to what it could be and how do we get there? But I would say, similar to how you passed a motion last year that was really intended to be a message to the board.
Yeah.
Passing along those same messages as it relates to what you would recommend. Basically, our communication strategy is around
I like
capital
the
projects.
concept. I know for anybody that hasn't looked at that website to look at the projects that are proposed, there's only a few projects that are actually on the website right now. But the idea behind it is very good. It provides as much detail or more than we've ever had before in that 150-page document last year that we couldn't come to a consensus on. But like I said, the other departments would have to populate a similar type of website, or like Director Rice said, you have to have it all in one location and maybe have a pop-down menu for each of the directorates with their specific projects on it. But it doesn't get us to understanding the CIP for this year.
Or maybe by the end of the year, like the plan was,
Maybe by the time it gets to the BOCC, but not by
BOCC.
the time we make a recommendation to go forward.
That's true.
Okay, I mean, so without even hearing any more, my recommendation would be that, yes, the propagation of a site similar to the one that is proposed for Public Works is a move in the right direction, both for the visibility of the community and the citizens and the Planning Commission, but it's not there yet. I don't know. Sorry. And I'm gonna finish right there.
My understanding based on
presentation is that the end of this was to have us move to schedule a public hearing on the CIP. Do we have any objections to that? Because I can motion, okay. I'd like to move to set a public hearing on amendments to Appendix G of the Thurston County Comprehensive Plan docket item CPA for 2026 to 2031 capital improvement plan for August 6, 2025 at 7 PM or soon after.
I'd second that.
There's a motion and a second. Any discussion? All those in favor?
Aye.
Opposed? Motion passes. Okay. Thank you very much. Commissioner Pestier.
Culverts. I see on page 15 of 31. A lot of planned expenditures. So just basically a straight line, 700,000 per year. Every year. And it talks about in the stormwater section on page 14, 3,300 culverts, but going back to the page 4 of major accomplishments, I thought there had been a number of culverts recently upgraded. I'm surprised nothing's listed here in underwater, under stormwater or underwater and sewer systems. I think it probably belongs under stormwater, but we get some more information on what major accomplishments were made with culvert updates.
The Public Works Department drafted those sections that included the accomplishments they thought worth including. So I can pass along that it would be beneficial to add those in and get a list from Shannon and Xavier.
Please, I'd like to know about the culvert. And
You want
then,
specific ones or just sort of a tally of how many they've been able to replace?
Been accomplished in the last couple of years. On page 23, current facility inventory, it says capacity or size, is that all square footage? And I don't know, I couldn't find anything in there for the landing pad for the sheriff's bat copter. I must have missed it. Thank you.
I think we are now at item 7 on our agenda. Work session number 3 on the Black Lake Quarry land use amendment and rezone.
Do we have some updates for?
Yeah, I think Claire's.
There's
Claire, I'm not sure. I don't think I can hear you right now. Cannot hear you.
Oh, yeah, we can't hear you, Claire. This is a ruse to shorten the meeting. It's working.
I wonder if you might want to switch your microphone using the little caret next to the mute button. And see if there is perhaps a different microphone that it thinks you have that is not working. Alternatively, staff could put the call-in number in chat and she could talk via phone.
Derek may also be able to cover it.
Yeah, if we need to, Claire, I can pinch hit for you. If you want to share your presentation.
I just held up a finger, so it sounds like something's in progress.
Well, there's troubleshooting. I'll just get us kicked off from where we left off. from our last conversation about this. So we had the goal of the last work session was to set a public hearing. And we had some discussion about that. One of the questions that we had was from the planning commission about whether or not it's required. We had just kind of assumed that it was. We also just dig into the code, and there are code references about a public hearing. So I think our suggestion is kind of no matter how people feel about this, I think the right move, next step is to hold a public hearing, hear from the public, and then make the planning commission recommendation. And I think Claire's original suggestion was was gonna be for August 6th, also at 7:30. So an alternative time might be.
I think we just set one for 7 o'clock.
We set one for 7 o'clock?
Yep.
And we did have the caveat or near. So there was a little flex room in the proposal.
So I think depending on how much time you all would want to put on the calendar for a public hearing for this project.
I don't mind having two in one night. Might make for a long night, but I want to hear from the public.
When are they not long nights at this point? So.
I'm pretty ready.
Yep.
I move to set a public hearing for Black Lake Quarry land use amendment and rezone for August 6, 2025 at 7:45 PM.
I second that.
It's been moved and seconded. Is there any discussion?
Do we need to set a time?
He did 7:45.
That's what I'm asking. I don't want to set a time.
Oh, 7:45
Do it
or
immediately after the CIP.
Is that possible?
Do we have to notice a specific time or?
It should be at or around. And so CIP probably won't get as much. And so you could do that one first and
Starting them late's fine, starting them early is not.
yeah, yep, you can start them late, you can't start them early. So you don't want to say 7:45 with your CIP as the first one, because you might be just sitting here for 40 minutes.
So 7:30.
I'm sure you'll find something for us to do. But yeah, I think we should.
You could say at or around 7 in the same way you said at or around, at or around 7 for CIP. And just have the CIP one first.
Yeah.
Okay, so have them both at or around 7 PM.
Yes, starting no sooner than 7.
Okay.
Um,
You consider that friendly, and there is a second. All those in favor?
Aye.
Aye. Any opposed? Mr. Fishburne? Yeah. So, terrific, thank you. Well, I think that accomplishes 7 and 8 on our agenda.
You good, Claire? Thumbs up?
Yeah, do you happen to be able to hear me now? All right, well, thank you for setting the hearing. That's really most of what I had to present was that the code would like you to have a hearing. So yeah. Sorry about the technical difficulties. I don't know what happened. I used the manual mute button on my keyboard and that might have just sets a chain of all kinds of Zoom events off. So thanks for your patience, guys.
Would you have the due out that we asked for on the critical aquifers?
I do have that. Yeah, I didn't know if you guys already made the motion, if you want to see that, but I can pull it up for you really quick if you'd like to.
Great.
Great. So, yeah, our main questions were about the hearings process and those groundwater test hole locations. This map is from their most recently submitted, as of 2024, 5-year mine review permit. This is a map, I believe, that was produced in 2023 as part of their ongoing kind of compliance and monitoring for the mining operation. They have to do regular groundwater testing based on the dates of the reports that were submitted under that permit. It's happening once or twice a year. And these are the locations, the white dots with the black circle are the locations of the test holes for groundwater monitoring on the site.
Okay, I noticed you have like PW one and then you have LR 2-3. Is there something different between the PW and the LR?
If there is, I am not enough of a groundwater monitoring expert to know that. I just know that these are testing locations for the site. As far as that level of detail, I'm not aware.
Okay, so there's currently 8 testing locations.
Mhm.
And do we have the results of those tests?
I mean, it's the full technical report, which I can provide to you guys. But I don't have a summary of those results, no.
Yeah, I mean, I think the most interest would be in what types of level of contamination is in those tests. Just like when I do a well test at my home for my well, I want to know what kind of contaminants are down there and what percentage they are as compared to what the normal standard is.
Okay. Yeah, we can put that information together for the public hearing.
And I'd like to make sure that we get that prior to the public hearing. Because sometimes those technical data sheets can be a little bit to go through.
Yeah. Yep.
We can double check and make sure that, I believe these wells are for their NPDES permits. So we might have to dig around through, ecology to get a hold of these, but.
The test results?
Yeah, versus like public wells where we already have access to all the data. I'm just
Wouldn't
not
the
sure.
company have those?
I mean, yes,
Should.
they would. It's just,
And if they are for their NPDES permits, I believe all of that data would be publicly accessible online, just not in our normal
Format.
net that we cast.
Yeah, I mean, obviously, there are certain things that you want to pull out of any type of water testing results, particularly when you're looking at an aquifer and recharge areas. So those are the kinds of things we'd be looking at. You know as well as anybody what that would be.
Yeah, and they would be held to the Department of Ecology's water quality standards.
Yeah, I was talking about lead and other pollutants and stuff that could go through those things.
I'm not sure what's in their permit, but.
Okay. All right. That's all I have.
Okay,
All right.
thank you, Claire.
Yeah, of course. Thank you all.
Okay, number 9 on our agenda is work session number 36 on Thurston 2045. Follow-up recommendations. This was scheduled for an hour. We can do it in about 20 minutes. We'll be back on track.
There you go, Maya.
Thank you, Planning Commissioners. Maya Teeple, Senior Planner with Thurston County Community Planning, here to talk about Thurston 2045 tonight. So I don't have a PowerPoint for you all. I will go over the game plan for the next couple of work sessions. I would like to start working from the June 4th memo that we provided and just going through by the chapter numbers, the public hearing version chapter numbers, I should say, not the Planning Commission updated ones. And we'll just move through the chapters piece by piece and use that memo as a guiding tool. At our last work session on the mid-June work session, the Planning Commission did have a couple of follow-up requests. The first was on the tree canopy codes, which Ashley is here to give an update and a summary of that tonight. And then the second is a definition for regenerative agriculture, and I do have that for the Planning Commission. I think it would be best that we talk about that with the natural resources chapter. So if you all are comfortable, I'll just delay that update until we get to that point. But without getting into too much, I want to see if Ashley has anything that she wants to share on the tree canopy pieces.
what were the burning questions that the Planning Commission had so that I can make this pointed and go faster? On all of them, is it the forest lands conversion or tree canopy assessments?
Was forest land conversion in reference to canopy assessments. This was from our conversation about the Thurston Climate Action recommendations.
Yeah.
So that was the nexus of it, but I think it has
It's branched,
Yes,
it's
I
branched
believe
out, okay.
Sorry, you can't go to the root, we need the full canopy.
So it's fine.
We need an epicormic
Yeah.
discussion.
So when we embarked on the journey with the planning commission and the community for updating the forest lands conversion ordinance, we started with an assessment by the Thurston Regional Planning Council about areas with the highest risk of conversion. So areas that are currently forested, that are not in long-term forestry, and where we might see canopy loss into the future. And not surprisingly, it was all of our lands that are currently zoned RR15 that aren't currently developed or are sparsely developed in, trees on the rest of the parcel. That really informed the forest lands conversion update that came before the planning commission. So it really focuses on rural areas. It only applies to parcels that are being developed. So maybe they were in forestry, but now someone's wanting to build a single family home. What happens then? So the forest lands conversion ordinance, as it's currently written, does allow people to cut trees. However, we now have the most robust replanting measures in the state. So there are assurances there that replanting is going to be done on those sites where they have removed trees to build houses. We also have special provisions for folks who are wanting to cut down trees, let's say for agriculture, where they would have to submit a farm conservation plan to demonstrate they are indeed looking to create a pasture rather than just, a large lawn, before they'd be able to do that.
Is there, so in terms of tree clearance, is there a maximum or anything like that on there? Given that replanting is happening, but given the timeline of replanting, when that actually becomes canopy is going to be a long time from now. So like, I guess, is there anything to minimize the canopy loss in the intervening 50 or 70 years? If you're like taking out.
There are, written in there are protections for, there's a number of different tree types. I don't want to cite specifically, but you've got your significant, I think it's heritage, I want to say legacy. It sounds sort of like those, but there's at least multiple categories where a certain percentage of those trees need to be retained on the site. But the rest of, it can be clear. The purpose of it is conversion. So if you're just looking at a forest lands permit, you go to DNR. What we were trying to do, if you go to DNR, you don't have to follow any local critical areas regulations. And we have pretty stringent critical areas regulations here in the county. People were essentially going to DNR, getting a forest lands permit to cut all the trees speculatively, and then putting it on the market as being already logged. And then whoever bought the lot was sort of handed like well, now what do I do? So now, like, we've really tightened up the ability to get a moratorium or essentially a release from the DNR permit requirements, and then getting people in the track of getting in the conversion permit through the county, applying local critical areas regulations to any of that conversion, and then also having our replanting requirements, which mirror the replanting requirements that the state has, only we have some allowances for, yes, you are going to be building a home and maybe some outbuildings on this site, but otherwise, like, it really mirrors what the state DNR replanting requirements are. So it's not perfect. It doesn't address what you're bringing up, but it is the most robust one in the state.
Mr. President.
So are you saying that logging in the county can only happen for development or for agriculture or for?
No, logging can happen, but that, we don't even look at those permits. Logging permits, forest practices permits, we're not part of that review process. It's only DNR. So this is only if you want to take it out of, like, cut the trees permanently because you're converting it to a different use, that you would come to the county.
So when landowners who own 5 acres or more and they have a house on those, when they choose to, they may have lived there 10 years and had the house there for 10 years, but they choose to cut half the trees on their lot. What permit do they have to file for, and how does that happen?
So it depends, talk about branches, there's lots of different branches on this, so there's a certain amount of trees that can be cut without getting any permit. Once you get above that threshold, there's an acreage and or a board fee requirement tied to that. Then essentially you apply for a forestry permit and it has replanting requirements that have to happen within 3 years. Or let's say you don't want to replant and you want to use it for ag, then you come through us for a conversion permit, which now still has replant, like, so we didn't have any replanting before. And now we have really robust replanting
And
requirements.
now is like a year ago or pretty recently,
You were on the planning commission.
we passed it in the last 4 years.
No,
ago.
yeah, it's only like a year.
Yeah, you're not.
It's a year and a few months is when the board passed it, and so it would have gone to you about a year and a half ago. And we are working on an adaptive management plan right now, so the board asked us to monitor, because we were really trying to strike a balance, like, did we go too far in replanting and someone can't even carve out a space for a home? I just talked to Olympia Master Builders, government relations director yesterday, and he said he hasn't heard anything. So it's, at least right now, this balance seems to be there, and we'll just continue monitoring. But we'll be delivering that adaptive management report to the board here in the next few months. And then written into the comp plan is continued monitoring of tree canopy.
But anytime, like, say a lot owner with 5 acres wants to cut trees on their lot and sell them for lumber, they have to get a permit from DNR.
Depending on how many. It's 5,000 board feet. I couldn't remember the acreage. I was gonna look it up, just so I don't misrepresent it.
Commissioner Bartlett.
I guess just we've had a lot of conversations around canopy and connectivity and stuff like that. And I guess if we're talking about canopy, it usually does kind of imply more than one tree adjacent to each other. So I'm wondering a little bit about like, if there's anything around the language of like, because we've started to talk more about the way that these properties, like a property that's getting developed is connected to the properties or the lands around it. If there's a conversation around these canopies being contiguous or just a series of small trees kind of scattered.
And I think we're actually set up really well for that.
Great.
There are a couple of different pieces at play here too. So we have also new stormwater permit requirements that have us look at canopy, and that's for hydrology and runoff. We've got this conversion ordinance that starts to look at it on a parcel by parcel scale. We're starting to look at it at the county-wide scale, and there's this adaptive management component to our current code. So we've got, not only do we have a really good conversion ordinance, we've got good systems to keep looking at it and good kind of like nudges from the state. And when you're looking at it from a stormwater perspective, one of my favorite quotes ever from a stormwater engineer that I really respect. We were talking about forests in a different context as our position, but his point was a tree is not a forest, and for stormwater management purposes, you can't treat just a tree like a forest. Forests have their own kinds of benefits, and they operate in ways that are different than just a group of trees or even one tree. Like forest is very different. So being able to look at that from the stormwater perspective will help give us that level of granularity that we could bring into an adaptive management process. But I think we're set up exceptionally well, to be honest.
That's great.
How often does your LiDAR tree canopy map get updated? Will you see that being updated?
We're actually getting new LiDAR here pretty soon. So what we have now is 2017 and 2021 sort of Frankenstein version. And so they're doing a full new LiDAR flight, is my understanding. It takes a while though. I mean, 2021 took us like almost 2 years to actually get it in, get it processed.
Having a new one?
Ideally, I mean, I think it's a shared responsibility between when the state can do it or when we can do it. It's expensive. It's getting less expensive, but it's expensive.
Who are we partnering with on that?
You remember? You heard it from someone on your team.
I think DNR usually.
The DNR.
is the person who initiates that process.
So my concern, and I brought it up at the last meeting, was that based off of the tree canopy cover analysis, and we're hearing varying different things, but essentially one of the summary items is that we have slightly more than we thought, but we have next to no ability to create more. And with that being a pretty high level of concern, at the rate of loss we are still experiencing, I'm glad to hear we have some of the best practices in place for replanting and other treatment, but I mean, I remember the numbers we argued about: save 10%, save 20%, save 30%, and even just trying to move it 10% was unacceptable. And the arguments were like, we need to not reduce the building of housing. And I think with this added information about now tree canopy cover and where we stand, I feel like, do we have any opportunity in the comprehensive plan to address any of that to be more protective?
So a few things. We do have area for oak woodlands. So if you're talking about, you know, we don't necessarily, if you look at prairie soils, we don't necessarily want Doug fir encroachment, but there's still a lot of opportunities for prairie restoration and oak woodland restoration on those prairies. And then, I mean, I think we looked at it at a very big scale, you know, the hexagon represents so many acres. But if you look at all the work that's being done to try to replant our riparian areas, we have a lot of riparian areas. It's not gonna be captured in the hexagon format, but I mean, I see a future where although the full hexagon isn't gonna be filled in, you're gonna see a lot more replanting and restoration where it really should be focused or prioritized, which is along our salmon-bearing waterways. I don't know if you have anything to add to that.
I think how far down the rabbit hole I wanna go. So,
I'm still asking the question, can we be more protected?
I mean, you could always turn the dial to 11. There's a question on whether or not it balances, kind of the things we wanna balance, or
Oh, your
whether,
11 is my 5, but that's okay.
right. So there's a question like why you wanna do it, what you're trying to protect, how much you need to protect certain things, the timescales and how that operates here. It's really complicated. Like one of my favorite examples is King County's done a bunch of work and they're like 50 years ahead of us as far as development. They've already faced the pressure that we've faced. They have, you know, made mistakes and they've learned. And what they do find is that over time, these landscapes do start working again. We might not have 50 years to let it kind of reacclimate, or to, you know, their big mistake was they didn't do a lot of stormwater management when they were building out. So, I mean, you could always turn it to 11. There's a question whether you need to get what you want out of the process. We do have some tools that we can use to look at that. And I think part of the adaptive management and part of the when I think about like looking at the stormwater permits and the analysis and what you need to look at for that, for like drainage design, that can include things like tree retention and looking at both site scale and like what happens when we build out in watersheds, like what we see happen in those spaces. So that is all to say, yes, and we have good tools that we're just starting to figure out how we can apply to figure out which dials we need to turn to see certain values, water quality, salmon, groundwater, to see those, what happens at full build out, like with all the assumptions that we have. We have implementation actions in the comp plan that.
And I will say, you all have spent most of your time on the planning commission focused on the comp plan and policies in the comp plan. Those dials and the changes that we need to implement to realize the vision of the comp plan is gonna come in code, like the Forest Lands Conversion Ordinance that a few of you were here and reviewed. It's gonna be lots and lots of pages of code and trying to understand like what those dials are. Because like the intention behind this one, it's wonky, but we built even the replanting standards to incentivize retention of existing trees. So it's a point-based system. It's not even a number of trees, it's points. So at 100 points, guess what? You get more points if you retain an existing tree versus having to go out and buy a bunch of saplings and be on the hook for making sure they survive through the drought season. So there are, like to Derek's point, there are a lot of tools and trying to just build in those incentives. So hope you'll join us, stay on the planning commission as we go through all of that in the future, because comp plan is going to be followed up with a lot of code updates if you actually want to implement it.
One of the pains that I'm experiencing, and maybe others are feeling this as well at times, when I drive around, I see developments, sometimes they're in the UGA, most times they're in the city, but sometimes they're in the county or right on the edge of the county. Mostly it's the UGA. This is where I get the most concerned. You see developments, you see new things getting built, and you see a huge forest. And then all of a sudden, you see like a strip of trees, one tree wide along the road, along a trail, and then everything else completely clear cut. And it just makes absolutely no sense to me if we have any input to UGA rules that we allow massive clear cutting so often. It just, when we're saying we're in an environmental emergency, a climate emergency, it seems like we're not taking that emergency seriously enough if that's how we let developers cut. So I really am looking for opportunities to stem that and protect that.
So that's going to be the subdivision code, Title 18, which is in a completely different, lives in a completely different place than forest lands conversion. Just in terms of like the kinds of code updates that you'd be looking at, those are, well, it's Title 18. Actually, if it's UGAs, there's also 21, 22, 23. But you're talking about subdivision standards and tree retention and subdivisions, and it is one of the
Not exclusively subdivisions. I mean, I've seen it done for buildings like schools and for, look at the new Lacey Police Station. It's got like a joke of a limited amount of trees right around the edges and totally clear cut the entire center. It's literally, and you know that previous timber practices were to leave a strip of trees along the roadway so that the public can't see everything that's clear cut just 5 feet behind. It's just a very odd practice that I don't understand why we support. And I hear you that you think that's subdivision and a different, you know, something we'll be working on years from now, but I want stuff in the comprehensive plan to be more protective.
So the UGA is going to be joint plans. I'm not discouraging you. I'm just trying to help guide you through this planning landscape we have in terms of you want to turn a dial where you have to turn it. And so UGAs are joint plans.
7 of them, I think, isn't it?
We have a lot of them. And
We just made some rules about UGAs right now, differentiating them from rural areas.
that was in the code update, so not in the comp plan. So when I say title 20, 21, 22, 23, that's development code, not the comp plan. It doesn't mean that you can't have policies that guide what those code updates are, but they would be coming through on separate tracks.
I think that's a good route to pursue, and I want to pursue it. I don't know where we're at with our timeline for tonight. I had a couple questions, but I really would like to punt them. But I think they're worth saying, which is this is we got at it a little bit with, when talking about Oak Savannah, but, I guess my question was like kind of in terms of, you were talking about ecosystem function, like what an actual forest is, what resources that's providing, and how canopy plans can implement that. I'm wondering what the equivalent of that is for prairie. Yeah, and like what kind of prairie protection and restoration we have in this plan. in that
Unless it's
regard.
oak, they wanna take it out and make it prairie.
Yeah, well, I guess that's what I mean, is like, making prairie shouldn't count against canopy, but converting prairie into something like even like as we're talking about on already owned property, converting prairie into turf grass or what have you is having the same kind of negative effect. That's affecting stormwater, that's affecting a lot of different types of like contiguous habitat. It's a thing. I don't know how we address that yet. I just wanted to bring that up as something that has been a concern of mine regarding canopy equivalent stuff. And then my other question, or I guess, is when we're talking about the lifespan of these trees, we're talking about, like 50, 100, 75 years, even just to get to maturity in some cases, or get to full canopy length, height. And that's a completely different ecosystem, given climate change. And I was wondering how that is taken into effect when we're talking about climate, or when we're talking about canopy, is like the species that are used, the growth, the ability for trees to recover under those environments versus now. How is climate taken into account for that?
So
Again, we don't have to have a full answer.
The code requires a tree conservation plan be submitted and that it is a diversity of species. As well as takes into consideration changes to climate. There has been, and we have resources available to folks that have questions, because there have been studies done in the Puget Sound region looking at which species we have today that will still be good species to have into the future. And it's supposed to inform like street trees, things like that, but we make it available to individual property owners to try to meet the tree conservation plan requirements.
Great.
Maya, do you have anything else?
I think it's best that we pick up on land use at the next meeting.
We are almost exactly right on time. Agenda item 10, staff update.
So we'll pass this around. Mr. Fishburne, have one of these. So we talked about some of the the CPAD changes. Here's an org chart. This is, I think, the third one I've seen since I've been here. Lots of helpful. But this shows how we've split the what was Brett's old team into.
His photo's so close to his face. Everyone else is like my whole head. It's like high. It's true.
So.
Do we have the most important addition to this?
Do we?
We got you.
No, it's not on there. Guess who's back in CPAD?
Oh, yeah.
Holly.
Oh.
For those of you who
Where
are
is she
old
at?
CPAD. She is
You
her.
better get her?
No,
Elena.
Polly came back to the administrative services team with Elena. She has family that has moved to town recently, and so she wanted to have a part-time role. So she is in a part-time role. Maybe she'll make an appearance at some point, because I know she misses you. But we are super excited about that. So that the little blank square there under Elena is now Polly. Let's update this again.
I think these need addition numbers.
No, we don't want anyone to know.
It does have a revision date. This is effective May 16th.
Oh, yeah, we have a few other changes.
For May 17th.
Yeah, all 2 days. It was accurate.
Yeah, it's been a lot of work to fill all of the positions from the domino effect of folks moving upstairs.
But this was the only staff update.
Okay.
Talk about.
It's fun to see who's smiling and who's not.
I just, FAIR, in case you didn't know, FAIR is part of CPED, and the FAIR is coming up July 31st through August 3rd, so please put it on your calendars. and boogie on down to the fairgrounds.
Is
We
a
appreciate
swine
it.
Spa.
There's a swine spa. There'll be peacocks. It's fun. Oh, turkeys on a stage being guided by the cutest 4-H kids ever. Like, please come. And then we'll be sending this out with the next comp plan update, but I just thought I would highlight, that Thomas released a new community engagement toolkit. It's a pretty robust collection of resources that are intended to support our community organizations in participating in our comprehensive planning processes. So pass it along if you see it come through, but we'll be sure to send that out to our comp plan email list.
Good deal. Any other 2045 update, Maya?
Nothing else from me.
Okay, then let's go to calendar. Like we have our next meeting on July 16th. We think we will have a quorum, or is there anyone that will not be here, I guess is the correct question. Hearing anything so far, so that sounds good. And then August 6th, we'll have a couple of public hearings.
I'll be out of town.
Okay,
I'll be out of town too, Joel, on the 16th.
on the 16th?
Yeah.
Okay.
We should still have quorum.
Yep. Okay. Anything for the good of the order? Okay. Well, would you look at that? We landed this thing a couple minutes ahead of schedule. Having no other business?
When the schedule is 3 hours. Meeting, are we really patting ourselves on the back about that?
It's a hostage situation.
I'm gonna take the win.
Thank you.
Thank you very
Have a
much.
good night. Thank you.